It will be continue. So I'm little accommodation because issue is almost same. I'll make my submissions. as
So no
soon as-
issue in which in court number 1 matter.
That is different.
Ah.
The argument is going on. That is why I'm paying for an accommodation.
For
this
these
matter,
matters.
if
For
it's
these
serious-
matters.
Well,
Your matter is item number
17. I'm for a respondent.
17. Okay.
The department proceeding, they are challenging the other.
All right. We'll as and when the matter is called up, we'll consider that.
Lordship directed me to file additional affidavit in item 10,
Yes.
which I have filed, Lordship, but it's not a part of the record. So may I be allowed to call for that, Lordship?
Have you served copies?
Yes, Lordship. Copy, sir, on Saturday, Friday itself.
Okay. Yes. Yes.
Lordship, in this matter also, we have filed our affidavit, additional affidavit,
When?
Saturday, Lordship.
So bring it on record.
Okay.
Yes. Have you received copies?
Yes, yes.
You have received
Already
copies.
Yes,
You wish to file any reply?
yes.
You are filing a reply.
Yes. File
It is submitted by Mr.
as per regular.
as Boiragi, learned counsel for the petitioner, that an additional affidavit
Yes, Lordship.
has been served on the petitioners, which is stated to be filed on behalf of the respondents. He prays for 3 weeks' time to
Before effective.
complete his instructions and file rejoinder if required. Mr. Sharma does not object to the prayer made. Accordingly, matter stands adjourned for 3 weeks. 3 weeks.
Fix the date or not.
Not now, let it come after 3 weeks. Yes.
Obliged, Lordship.
Item 5, none appears passed over. When the matter gets called up. passed over. None appears passed over. Passed over.
May I please, Lordship? Lordship, I am on behalf of my senior Mr. R.C. Paul. Due to illness of his elder sister, he could not prepare the matter till Lordship. Matter may come day after tomorrow.
All right, day after.
Much obliged.
Other affidavit.
Yes, that is not a part. I have to call it.
Yes, Mr. Paul,
Yes, my lord.
we are taking it over day after.
Day after tomorrow, my lord.
Wait, wait,
Eh?
wait, wait.
My lord, because I come back today from the work. My elder sister is seriously ill.
All right, all right.
Day after
Item,
tomorrow, I'll be.
yes, okay.
Much obliged.
Item 10, let the petitioners appear. Let it be called up.
Lordship.
Second half.
Yes, sir.
Happy is the Lordship. Mr. R. Pujari appears for this matter. He's on legs in court 5, your Lordship. Pass over the matter for the time being.
All right. Time being. What? Yes,
Lordship, the matter may be passed over for time being, Lord. My senior is coming.
what is this timing business? Passed over.
Article 14. My lord, these two matters, my lord, and along with other matters, this matter, my lord, relates to, my lord, termination of contractual employees in NRC, my lord. And what happened, my lord? These petitioners are terminated in 2020, my lord. And in 21, my lord, the junior assistants also terminated, my lord, all over the state. And 23, the CPS officers also terminated. So, my lord, this honorable court, my lord, the junior assistants and CPS case is, my lord, fixed day after tomorrow, my lord. The issue is the same, my lord, regarding the validity of the termination of contractual employee of the NRC, my lord. So, my lord, may I pray for listing this matter on day after tomorrow, my lord, along with these matters, my lord?
We are passing it over. You produce a copy of that order. And then we'll pass necessary orders in these matters.
My
All
lord,
right.
for today, my lord, the matter may be fixed on day after tomorrow, my lord. I will produce the order, my lord, day after tomorrow.
Let it come next week. Let it be next week.
My lord, the matter may be heard on 5th, my lord. The issue will be, my lord, heard.
We'll hear it. We are not saying we'll not hear it. Let the matter be listed next week. We will see what can be done. You
Well-
produce a copy of that order. We'll have to be satisfied that they are connected matters or issues are simple.
Yes, my lord, for my lord, after some time, I will produce the order, my lord.
So we are listing it on
My prayer was-
12th.
My lord, my prayer was on 5th, my lord, because the
For?
issue- on 5th, my lord, the other two matters is,
We don't know that, Mr. Counsel. You can't make a prayer like that.
my lord, I will.
We
produce-
can, you can't make a prayer that these matters are connected, do it. You'll have to produce some order to
Yeah.
show us,
My lord,
merely because these people are terminated, they were on contractual employee, may not be this one and the same.
I will.
Their
produce-
posts are different.
Yes, my lord. At 2, my lord, I will produce the order copy, my lord. You will,
All right, at 2.
oblige.
Yes, Mr. Chakraborty, yes. Item number 12. Yes,
My lord, 2017,
who's for the APDCL?
my lord.
APDCL Council. Yes, flash code. Yes,
I prepared a day check, my lord, and my ground, my lord, we can take up.
what is the issue about?
My lord, the departmental procedure was held, my lord.
Hmm.
Finally, the punishment has been imposed that I should be compulsorily retired, my lord. And that, my lord, 1/3 of my gratuity and pension to be deducted infinitely, my lord.
Hmm.
Now, the punishment, the impugned order, my lord, page 87.
Yes.
88 will be the relevant part, my lord. The undersigned has given thoughtful consideration to all the facts and circumstances of the case and also taking into account his records of past service under board and company. It is concluded that the end of justice will be made if the proposed penalty of termination of employment is reduced to compulsory retirement with 2/3 pension gratuity on the charge officer.
Yes.
Now, so far the compulsory retirement is concerned, my lord, this order was passed on 9/8/2016. But my due date of retirement was very near, my lord. That's why it was, my lord, 30th of September 2016. So far this order is concerned, my lord, compulsory retirement is not causing me much prejudice, my lord. Though I have challenged the entire punishment, my lord, the only thing, my lord, the recovery. Now, I'll go to the, my lord, the annexure and everything, my lord. My
No,
short
no,
submission-
what recovery?
that 1/3 of gratuity and 1/3 of pension infinitely to be deducted. Infinitely, my lord, not for a time period, my lord. My brief submission in this regard is that
When did you retire? When did you superannuate?
I was supposed to retire on 30th of September 2016, but compulsorily retired on that date, my lord.
Uh,
Near to that, my lord.
Hmm.
August, 1 month prior to that, my lord.
Then
why
what
my lord-
happened? What happened to the appeal?
Appeal, they have passed a mechanical order, my lord, without giving reason. I'm not getting my
Where is the order? Appellate order?
appellate order 105, my lord.
105. Yes.
Just a mechanical order, my lord. Without consideration of the material, anything, my lord. No reason cited, no consideration has been given, my lord. Even the order of penalty, my lord, nothing has been considered. Only consider the inquiry report and now prima facie, my lord, Lordship may kindly bear with me. Prima facie, my lord, why this recovery order is bad? Recovery order is bad because there was no charge that I have caused any kind of loss to the corporation. That something should be recovered from me. In the finding of the inquiry report, my lord, there was a charge of theft against me. Theft is, my lord, what I'm saying, my lord, what is theft, my lord? In my residence, my lord, they say that I have taken an temporary electric connection within violation of the procedure, my lord. That was the charge only, my lord. Now, in the charge, there was a theft. In the inquiry report, it is categorically stated that the charge of theft is not proved. No loss to the corporation and Gratuity Act, my lord, clearly lays down that gratuity can be curtailed in two situations, my lord. Firstly, my lord, there has to be a termination and there has to be a loss caused to the authorities, my lord. Otherwise, no gratuity can be curtailed, my lord. So if I
Yes.
confine my submission only to this recovery part, my lord, the matter is very short.
Yes.
The date chart, Lordship may kindly see, my lord, the fact in brief, my lord.
Yes.
Lordship, I'm appearing on behalf of Counsel KP Pathak. He's on his legs at port 12, Lordship.
You can't be helped. You be present here.
Okay, Lord.
Will do.
Yes.
My lord may come to page 30, 31, and 32.
Yes. You take your seat. Take notes, whatever he argues.
Yes, sir.
Yes.
My lord, while I was posted at Golaghat,
Yes.
page 30, 31, and 32, my lord, I did the date chart, your lordship will get it. my lord. And it's here 1, 1A, and 1B.
Take us to the inquiry report.
My lord. Page 72.
72. Hmm.
These are the charges recited. Then 7 witnesses were examined, my lord, page 73. Finding page 77, lordship, can you see? Some documents have been referred here, my lord.
Hmm.
The documentary evidence is considered in the course of inquiry. 1, 2, 3, 4, and 5. None of the documents are mentioned in the list of documents, my lord. I'm just pointing out the informatives in the,
Did you ask for these documents?
my lord, I did not ask for, my lord, they cannot rely on. I'm not saying that copy was not given to me.
Huh.
I'm saying that anything not there in the list of documents, they cannot rely without giving notice to me regarding that.
But you have been served copies, you say.
No, these documents, my lord, they have relied on their own, my lord, in the inquiry. Lordship, kindly see the list of date, my lord, page 50. There are 3 documents, my lord.
Hmm.
None of these documents are these documents, my lord.
Hmm. Did you take that ground before the appellate authority?
That I have to take it up, my lord. Above that, my lord, that
Yes.
the second paragraph, I may read, sir, a very 2 page of the inquiry report, my lord. That would,
So read the entire inquiry report
My lord.
because the inquiry report will reveal what are the charges.
my lord. Page 72, my lord.
Uh.
Charge number 1,
Yes.
theft, charge of theft was there, my lord. Theft, fraud, and dishonesty in connection with the business of the company. The report submitted by CBO dated so-and-so revealed that Mohammed Abdul Rashid, the CEO of Golaghat Electrical Circle so-and-so, by taking advantage of his official position, compelled his subordinate staff, namely so-and-so, so-and-so, and so-and-so, draw illegal service connection to his residence situated at Kayapatti, Golaghat. This misuse of power created resentment among the public and became a subject of criticism to the officers of APDCL by public. The photograph in the file showing existence of welding machine in house of Mohammed Rashid and existence of a photograph showing the drawn of an illegal connection and statement recorded CBO team of so-and-so, so-and-so, so-and-so gives strong indication of an illegal act committed by Mohammed Abdul Rashid. From the above, it is apparent that so-and-so committed misconduct of theft, fraud, and dishonesty in connection with the business of the company, which is misconduct under the regulation, and hence he is charged under state regulation. So this is the charge, my lord. I took an extra connection in my house. And charge B, breach of ASAB officers conduct regulation so-and-so. The ASAB officers conduct regulation so-and-so lays down that every officer of the board, the company shall at all time maintain absolute integrity and devotion to the duty and do nothing which is unbecoming of an officer of the board. From the above charge, it appears that Mohammed Rashid has acted dishonestly with malafide. So on facts, my lord, only that charge that I took an illegal connection in my residence.
Where is the report of the CVO?
Yes, my lord. That is very important, my lord. On the basis of CVO report, this proceeding was drawn, my lord. Page 43, my lord. This CVO has not been examined in the inquiry, my lord.
Yes.
May I read it, my lord?
Yes, please.
As per your order and in continuation of the inquiry report submitted by my predecessor so-and-so, self along with a team of vigilance of Bijuli Bhavan, so-and-so visited Jorhat, so-and-so, and conducted an inquiry under my supervision to clarify the points raised in the state order. The details of the inquiry as sought for are furnished below. Kiran Kumar Gogoi, so-and-so, who previously posted at Golaghat Electrical Division APDCL. Golaghat, when examined, he corroborated the statement of so-and-so. He stated that Abdul Rashid, CEO, Golaghat Electrical Circle, Golaghat, requested Sri Gogoi to send a lineman to his house for certain tasks, and accordingly he informed Sri Navajyoti Thakur, Sahayak so over telephone to proceed to his house and attend the said task. Subsequently, on a later date, so informed Sri Gogoi that an illegal line was drawn into the house of Sri Abdul Rashid. Sri Gogoi has further stated that he brought the matter to the notice of DSA Golaghat, and he also requested Sri Rashid over phone to regularize the illegal connection drawn in his house, but Rashid totally ignored him. Sri Gogoi also stated that about a month prior to his drawing of illegal connection, Sri Rashid informed him about the requirement of the temporary connection to his house, but in this connection, no formal application or revenue deposited in the office for the said purpose. During the examination, Sri Gogoi further stated that he was not aware of the disconnection of the said illegal line from the house of Sri Rashid, as he already left for DQ for transfer. The statement of Sri Gogoi is placed at an so-and-so. Laksheshwar Chutia, so-and-so, also examined, and he corroborated the statement given by Navajyoti Thakur Sahayak. Sri Chutia stated that on 7/7/2014, he along with Navajyoti Thakur visited the house of Sri Abdul Rahman at so, and in the presence of Sri Rashid and other, and as per his direction, drew electric connection and fixed to his switchboard without connecting it to the energy meter. Sri Rashid further informed that this was an arrangement for a temporary period of 10 to 12 days for carrying out some welding work in his residence. On being further questioned, Sri Chutia said that he was not aware when the said line was removed from the house. Sri Paragjyoti Dotto, SD so-and-so, stated that regarding drawing of the illegal connection into the house of Abdul Rashid, he has already informed the AGM Golaghat Electrical Division through an official letter. On being proved further regarding the removal of the illegal line into the house of Sri Rashid, Paragjyoti Dotto stated that he was not aware about the date of the removal of the line, but however he stated that the said illegal line was probably removed on 21 line so at tripling time during shutdown at so feeder. The statement of Paragjyoti Dotto is placed so. It is observed from the inquiry conducted into the matter, including the statement of the above noted person, it transferred that the Abdul Rashid, CEO Golaghat so, Golaghat, by taking advantage of his official status, compelled his subordinate staff, namely so-and-so, to draw an illegal service connection to his residence situated at so. The misuse of power created resentment among the public and became a subject of criticism of the officers of APDCL by public. It would perhaps appropriate to mention that entire matter was in public domain and there was a big commotion among the public of Golaghat since the role of or function of Abdul Rashid, CEO, had widely circulated through a local daily so-and-so. Thus, the inquiry conducted by my predecessor so-and-so, the statement recorded by him, including the existence of a photograph in the file showing existence of welding machine in the house of Rashid, and the existence of photograph showing the drawn of an illegal connection, and the statement recorded by me of so-and-so give a strong indication of an illegal act committed by so-and-so. There is enough evidence exists to register a criminal case against so-and-so for conducting a thorough investigation for logical conclusion of the matter.
Yes.
Even if Lordship takes that the entire charge is correct, what happened actually, my lord, and a connection was illegally taken by me for some ordering purpose, for a temporary purpose. Therefore, my lord, here your lordship will find this connection was given by the ACB people. That's why the inquiry report it is held that the charge of theft is not maintainable, because everybody knew Even ACB also knew about it. ACB, that's subordinate. That's why theft is not there, my lord.
Theft,
The charge of theft is there, my lord.
theft, if you look into the Electricity Act,
Mal-
I think unauthorized,
Inquiry report mentioned that theft, it was not done surreptitiously, my lord. Other charges are proved, my lord. Only theft is not there.
Hmm.
It was with the knowledge of ACB people, my lord. And says that I exerted my position.
yes, then
So
comes the inquiry report.
Enquiry report, my lord. I'm coming back to enquiry report, my lord. 77. May I read it, my lord? Only 2 pages, I'll read, my lord.
Yes.
77, my lord. On 16/9/2014, Sri P. Datta procured a written report from Sayak so allegation. Illegal electric lines in the house of so, and he wrote a report to AGM GAD on the issue on so. And interestingly, same was published in newspaper Pratidin on so. A vigilant team headed by CVO arrived Golaghat evening on so and caused an inquiry in the house of CEO Rashid on so, but did not find extra electrical line in his residence, but submitted report on 30/9/2014 claiming that C. Rashid enjoyed an extra electrical line in his house. He alleged that vigilance obtained statements of selected witnesses which did not tally each other and not verified for confirmation. Enquiry team saw a welding machine and 2 bundles of cable in his house, but not technically examine probability of using same in additional electric line. No paper reporter visited the house and took photographs about the existence of additional electrical line. But if it came in newspaper, the CVO team failed to ascertain authentically, and so A. Rashid smelt a great conspiracy was held against him to malign his unblemished career. The documents, evidence, and considered during inquiry, charge officer is given ample scope and full liberty and natural justice to possible extent in every state. He is also allowed to cross-examine prosecution witnesses during examination, which he availed, and also allowed to produce defense witnesses, if any, to speak in his favor. But he could not produce, and hence he is examined as only DW in the proceeding. Finding. The following have been taken consideration the course of inquiry. A. Rashid took charge of CEO Golaghat Circle and reviewed revenue and performance of Golaghat Electrical Subdivision and anomalies like DPL connection of unauthorized consumer, non-stay of SDA in other staff at night, issue of false driving experience certificate to driver of hired vehicles by SDO. He brought this note to the notice of higher authority as well as to the concerned officer, which caused annoyance to the so. I take a pause here, my lord. Just prior to this CBO, just prior to this inquiry, my lord, you should find I was giving number of complaints to the authorities that all these illegalities were going on, my lord. Only to cause prejudice to me, because why I have highlighted all these things, my lord, this inquiry was initiated against me. I have enclosed this, my lord, annexure A1, BN, that is being mentioned, my lord. The Rashid, consumer number so-and-so, has obtained a sanction load of 1 kilometer and connected load of 9.9 kilometer in the year 2006 at his residence, so-and-so. Vigilance teams from so-and-so headquarters visited and caused fault and detected connection load of 4.448 kilowatt in his residence. Neither subdivision office carried load survey nor Rashid brought it to the issue of the notice of the concerned officer long 7.5 years, causing loss to the company. It is certain that the Rashid asked FME Kiran Gogoi to drop a temporary additional electrical line in his residence verbally. And in fact, Kiran Gogoi ordered his subordinate staff to do needful. As ordered so-and-so Thakur and so-and-so went to the house of Rashid and had drawn an extra temporary line from roadside LT pole in front of his residence, but did not connect it to any meter nor interconnected the existing meter to the house. And the task was performed in presence of Sri Rashid at his direction and advice. FME Kiran Gogoi and Sahayak so showed undue favor to their CEO, the reasons best known to them. Even Sahayak so was over enthusiastic and procured electric articles. So Sahayak Chutia carried the ladder from so complaint booth and completed the task. Being feeder manager, Kiran Gogoi was supposed to regularize the instant temporary connection, but he failed to do so, and the matter was passed to SDE P. Datta, but in vain. On eve of his transfer, Kiran Gogoi brought it to the notice of Sri Rashid for regularization of CEO, which CEO reported, saying that he knew what was to be done. The said temporary electric line is presumed to be existed from so-and-so to so-and-so. Shutdown record of so-and-so feeder logbook entry speak that shutdown on 21/9/2015 from so-and-so to so-and-so payment was taken by concerned lineman. Vigilance team did not try to ascertain technically use the welding machine and cable found in his residence, but consumption of electric current through the instant temporary line for welding, drill, iron material, etc. in his house cannot be ruled out. Being senior officer, Sri Rashid would have done these formalities through his SDE, Sri Datta, but he did not take steps, rather removed the line quietly when there was public excitement and the issue was published in newspapers. Ingredients of theft is not seen here since the matter was aware and in very much knowledge of SDE and FME. FME Sri Gogoi himself took active role in giving the safe temporary line to the subordinates. Company has provision to give temporary connection, which has to be done in the procedure and regularized afterward as per convenience. But in this instant case, line was drawn, but no meter is installed and interconnected with the existing meter. Such very suspicious act is deliberate deception with intention of gaining some benefit. Charge officer deliberately ignored to regularize, nor he asked subordinate staff to do the needful, fixed dishonesty on his part. Consumer Sri Rashid enjoyed temporary electric line in his residence from so-and-so to so-and-so, long 56 days, and removed the same quietly, either himself or under his convenience. Under the circumstances stated above, except theft, the very fraud and dishonesty as framed in charge number 1 and charge number 2 are proved beyond doubt.
Yes.
My lord. So this is the inquiry report, my lord. On the basis of this, the punishment has been imposed, page 87, my lord. My lord, in the
Yes.
page 87.
What is 87?
Is an impugn order, my lord.
Yes. '87 is the disciplinary officer's order.
Impugn punishment, my lord. That punishment has been imposed, my lord. Compulsory retirement and, my lord, 1/3 reduction from pension and gratuity. Yes, your lordship will find, my lord, only that what has been done, the fact, second show cause notice given, inquiry report has been given and all, but independently the disciplinary authority has not considered the material in record. কোন আছে unknown নাম্বার বলে পাওয়া কথা পড়ি এর খুললে খুলে দেখো
What were your charges again?
charges I have read my lord, in the inquiry report it is there, but
Theft, fraud.
Page
Dishonesty.
48, my lord.
page 48 is there and 72 I have read, my lord.
So theft was not proved.
That was not proved. And
That
nowhere
is the finding of the inquiry officer also.
theft, because other officers are all did it. They have, it was not done surreptitiously. My lord. Only they said that the procedural regularities he should have done as an officer, he has not done it. He can take a temporary connection, but he has to deposit the fees and all. That was not being done.
What is your defense?
My lord. The grounds, my lord, as a whole, I have narrated your lordship.
No, in the inquiry, how is it reflected?
In the inquiry regarding the inquiry report, my lord.
No, in the inquiry, what was your defense?
Well, I did not examine witnesses, my lord, and my defense is not reflected at all. My lord. My statement that is reflected, page 70, that will be page 77. That, my lord, I filed a complaint before some officer, and as a result of which, my lord, immediately the CBU report and
আপনার annexion 9 to positive, that is the reply by transcription.
page 78 top, my lord. I filed 3 complaints against that, what was going on there, my lord, all illegalities. Officers were not coming to duties, my lord, at night. It is Golaghat and they were staying at Jorhat. They, in their own quarter, at emergency time, they were not coming, my lord. So I was giving this complaint and immediately thereafter, my lord, within 6 days, my lord, the complaint came, my lord. My lord, 10/9/14, I have given the complaint. 19/9, my lord, the complaint was filed against me, my lord. Only within 5 days, my lord, 8 days, my lord, the complaint was filed against me.
Yes. Then,
Now, so far the inquiry is concerned, my lord, that I have mentioned, my lord, in the inquiry, my lord, lordship kindly see the documents which have been relied in the inquiry, that was not there in the list of documents.
yes,
And the inquiry report refers about some photographs. That was also not given. Page 72, it is mentioned, my lord. That is not listed, and that was
page number,
page 72, my lord. It refers to some photographs being taken regarding that illegal connection being taken.
72.
72. And 77 also, my lord.
Hmm.
The photographs in the file showing existence of welding machine,
Yes.
that is incorporated in the charge itself, my lord.
Hmm.
And in the inquiry, my lord, page 77 it is mentioned, my lord.
Yes.
And both the, my lord.
Where is your statement of written statement?
Yes, my lord. That will be page 51, my lord.
51.
Basically, my lord, I have said about the conspiracy that is being made for filing the complaint against those officers, my lord. And I also mentioned about photographs and all, my lord. Para 4, my lord, I mentioned about that, about Melis and all.
You did not cross-examine the witnesses.
It appears not, my lord.
Then? In your written statement, you have denied, but during the inquiry, you did not participate in the inquiry. No examination.
I was examined also.
But you did not.
From my side, defense, I'm cross-examining the witness and these intricacies possibly whether he understood all these things or not. They come to advocates much later, my lord.
Hmm?
They come to advocates much later, my lord. They do it on their own, on the advice of the staff and all, my lord. And my lord, my instruction is the charge being shown not that insignificant, my lord. He was not thinking that this kind of punishment would come, my lord.
Yes.
Now, now, so far the inquiry is concerned, my lord, I have prejudice, I have said, my lord, that documents were not given and that the impugned order of punishment and don't appellate order, my lord, both the orders are non-speaking. the authorities, they have not considered the materials and record. Yeah, they have narrated, inquiry was done, second shock was done, and this is the punishment. That is also not, my lord, permissible in law. If disciplinary authority, my lord, considering everything, including the inquiry report and other report, he has to make his independent mind regarding this, my lord. So that has not been done. In the appellate authority, also, my lord, one paragraph, it is finished, my lord. Now, this is one aspect of the matter, which is regarding the conduct of the inquiry, my lord, the infirmity. But the recovery per se is absolutely, on the face of it, my lord, illegal and not permissible in law, my lord.
What
Because
recovery?
recovery, 1/3, my lord.
Okay.
1/3. My lord, there was no charge of causing any loss. Therefore, there is nowhere, my lord, it has been quantified that this much of loss I have caused and this much is to be recovered from me, my lord. So there being no loss caused to me, my lord, after my retirement, my lord, there cannot be recovery from me, my lord. Gratuity Act is very clear, my lord. Should we kindly take the Gratuity Act for a moment, my lord.
Gratuity Act.
All the three conditions that has been given for recovery from gratuity that are not being satisfied here, madam. Payment of Gratuity Act 1972. As I said, my lord, due to compulsory retirement, my lord, I would not suffer that much, my lord. It was only 1 month. September, I would have otherwise also retired. August, I have compulsory retirement. At this stage, my lord, I am only concerned regarding my retirement dues, my lord. If I am able to convince your lordship that recovery was not permissible, my lord, I may not praise that part, my lord.
Yes, please.
My lord, section 4, my lord. Payment of gratuity.
Yes.
Section 6, subsection, section 4, subsection 6, my lord.
Yes.
May I read it, madam? Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for any act, willful commission or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent the damage or loss took off. B is more important, my lord. The gratuity payable to an employee may be wholly or partially forfeited if the service of such employee have been terminated for his riotous or disorderly conduct or any other act in violence of it on his part. If the services of such employee have been terminated for any act which constitute an offense involving moral turpitude, provided that such an offense is committed by him in the course of his employment. Now, there are three conditions, my lord. There has to be a loss and he has to be terminated. And this offense which has been alleged has to be done in the course of his employment. All these three conditions are not available here, madam. Allegation is I have taken a electric line in my house, not in the course of my employment, my lord. And then there is no loss, my lord. Nowhere it has been pointed out that any loss, nothing has been quantified, my lord. And I have not been terminated, my lord. Because they are paying me my this thing, my lord, other pensions and all, my lord. So termination had been that I would not have got anything, my lord.
Yes.
So this is the Gratuity Act. And so far, other aspect of the matter, my lord, my submission is that, my lord, there is no loss, nothing has been quantified, my lord. Therefore, entire recovery is not permissible in law. And that too, my lord, this recovery is infinitely, my lord. It is not for a limited period, my lord. till I'll get pension, my lord, I'll not get one third of the pension, my lord. Now, one aspect, my lord, I have forgotten, my lord, I'm pressing, my lord. That is also very important.
Yes.
Your lordship will find, my lord, from the time of issuing show cause notice, considering the inquiry report, my lord, taking my personal statement, and then everything has been done by the managing director, my lord. Even show cause notice was issued by the managing director. But the lordship will find the impugn order has been passed by the chairman cum managing director, my lord, one rank above, my lord. He did not do anything, my lord. Lordship, kindly see that show cause notice and everything, my lord.
Who did not do anything?
Chairman cum managing director, my lord.
He is your appointing authority.
No. Inquiry, lordship, kindly see page 48.
40.
48, my lord.
48. Yes.
Charge memo was issued by managing director. This is the drawal of the department proceeding, my lord. On being satisfied, managing director has issued the charge memo. Then, my lord,
So who is your appointing authority? Who is your appointing
after
authority?
being promoted, my lord, they may say,
My lord, the chairman is appointing authority. And as per our regulation authority 6, I have brought the regulation. I'll show it to my lord. I'll satisfy my lord that. I'll satisfy the point which he has raised during my question.
if that be so, my lord,
What is your challenge in respect of the notices issued by
my
the
lord,
same person?
I am saying that, my lord, right from the time of taking the decision to hold a departmental proceeding, then, my lord, my second show cause notice was issued by managing director.
No, you are saying that he is the same person.
No, I am saying this is a different person. And their inquiry is being held by, considered by all materials, show cause notice is issued by managing director. And the CMD, who does not know anything about this, my lord, he has taken a decision on my
No, so who is the appointing authority? Who is the disciplinary?
As they saying, my lord, the chairman. They're saying, my lord, that
So chairman has passed the order.
well, how can he pass the order if he does not know anything about my proceeding? It is, my
He
lord,
is relying on the inquiry report.
my lord, show cause notice also he was not issued, he didn't issue, my lord. A person who is imposing penalty on me must be the disciplinary authority, my lord. And who
So
has,
who is the disciplinary? That is what I am asking you.
no, according to you, my lord, the CMD would have been the disciplinary authority. But in this case, then the show cause notice goes, my lord. CMD, the managing director issued the show cause notice, my lord, that was without jurisdiction. If he is not my appointing authority, if he is not my disciplinary authority, my lord, how can he initiate a departmental proceeding against me, my lord? Entire proceeding was conducted by managing director, my lord. Only at the time of imposing punishment, CMD came into picture, my lord. That's why, my lord, that impugn order is absolutely not non-speaking order, my lord. CMD did not know anything about the inquiry, my lord. So this is one aspect of the matter, my lord. Another aspect, my lord. During that inquiry, my lord, there is something admitted by them, my lord. My dues, my lord, I'm saying, my lord. During that inquiry process, my lord, my increment was held out. 2015 and 2016, increment they held up. They cannot do, my lord. Proceeding was going on, my lord. So ultimately, they have said that was done only because proceeding was pending, my lord. So along with any other relief which I may be entitled, my lord, my increment of 2015 and 2016 was held up. 16, in fact, I was compulsory retired, my lord. That they have admitted, my lord. Page 64, Lakshmi Kali Sima. This is not connected with the departmental proceeding, my lord. Directly. 64 Lakshmi connection.
Yes.
Paragraph 17, I have mentioned this, my lord, and in their reply, they said that we have no comments. 2016 and 2017 increment was not given to me. As I have submitted, my lord, I have retired long back, only getting my provisional pension till date, my lord. I have not received gratuity, my lord, suffering a lot. So, my lord, if they cannot justify that recovery part, my lord, I'll be happy with that, my lord, and I'll not go to the intricacies of the departmental proceeding, my lord.
Yes.
All right.
Are you relying on any authorities?
Authority here, I have not
All right.
thought, my lord.
Yes.
First of all, my lord, I'd like to apologize. I've come late. I was on a different court. I'm on legs, my lord. That's it.
All right.
My lord, I'd like to take you to the annexure 2, my lord, page 34, my lord.
Mm.
Of the repetition.
34.
4.
Yes.
My lord, this was a report to the Assistant General Manager by the Subdivisional Gulaghar
Mm.
on 19/9/2014. My lord, the report says the load survey with checking of metering installation and connected load of individual household consumer under each TTR are processed under the subdivision series problem also faced by the officers deployed for the purpose. Such survey carried out against DTR number 606 on the last 9/9/2000 and the deputies also provide 2 officials from the circle, Sri Utpal Goswami and Probito Sahayak for the same purpose to assist load survey. Accordingly, the survey work started headed by Sri U Goswami, JM, which take you have visited on the way to Suratpur, AP was I also present there on 9 September with FME concern. Number of consumer penalized with assessment bill for additional load and meter was also there. Residence of Deputy General Manager. The residence is the petitioner here in my lord. Left by the group and our report also received about 1 additional service connection from the pole. After checking at spot and going through the record, it has come to our knowledge that connected load is 0.9 kilowatt from the date of service connection and no any test report for temporary connection or any document of service connection found submitted by the consumer against the extra service means connected from the pole where actual service connection also exists. Hence, this additional service connection becomes hooking as there is no meter connected. And my lord, thereafter the details of the consumer profile.
Yes.
My lord may see name of the consumer Abdul Rasid, CTR number so and so, DTR number so and so, B extra service connection. As extra service connection as found by the pole without meter is hooking, photograph will speak the truth. Now assessment bill to be prepared with the effect of date of connection as stated by the line for 12 months. Many people will be confirmed in this case. Provisional assessment bill against the connection load on the basis of the unit. Now this submission before you for further directive to take action as required. Now, my lord, this point that he has taken service connection or not, he himself has paid in 2015, which I have annexed in my affidavit in opposition.
Have you taken steps to penalize the unauthorized service connection?
My lord, the unauthorized service connection that was there, my lord may see that every theft is not unauthorized use of electricity. So therefore, my lord, what we had to prove, my lord, even that this division bench has also categorically stated that every theft may not be unauthorized use of electricity and not every unauthorized electricity may be theft. So my lord, this part that whether there was an unauthorized use of electricity or not has been categorically proved by because his payment for the extra connection was done in 2015. My lord may see.
No, the query of the court is not that.
My lord.
Query of the court is if there is theft.
My lord.
With or without unauthorized
My lord.
connection, then
There will
the
be unauthorized use
regulation
of electricity.
rules prescribe how to recover, what penalty is to be done.
Yes, absolutely, my lord.
Now, if you have arrived at a finding and if there is a finding that yes, there was a theft,
No,
did you take any steps to recover this or impose any penalty for the losses caused?
I'll get to it, my lord. My lord, just before that, my lord, let's submit that. My lord, every theft is an unauthorized use of electricity. I agree with my lord. But every unauthorized use of electricity may not be theft. My lord,
How is it relevant?
yes,
for-
my lord, that is relevant in this regard is because, my lord, that there was an extra connection that this person had taken. And the payment of that connection was made in 2015. Hence, it directly shows the point that whatever the load inspection and whatever the inspection that was done by us, that was paid by him in 2015. And that, my lord, may just refer to my affidavit in opposition once, my lord. My lord, page 16(1).
So if it is paid by him, does it become regularized?
No, my lord, that is where the point is. It does not become regularized.
Ah.
Because, my lord, what is the charge that he has been applied to? My lord may see page 48.
Yes.
Theft, fraud, and dishonesty in the connection with the business of the company. And later on, the theft was
So
dropped.
whether it is theft or not
Later
theft,
on, my lord, later on, the theft has been dropped by the inquiry officer that there's been no theft.
ah,
So the only thing that remains is fraud and dishonesty.
so that
So
is,
that means a misconduct in his
So-
service.
no.
Yes, my lord.
If there is no theft,
My lord.
where is the fraud and dishonesty?
My lord, there has been fraud. My lord,
The issue is that he unauthorizedly got a service connection.
my lord. Without
You want
process,
to say this is not fraud,
no,
this is not theft.
my lord, I am not the same under the inquiry.
You
report.
means the
Yes.
APDCL.
The APDCL after inquiry, in the independent inquiry, came to the conclusion that there's been no theft.
So if
So
there is
my-
no theft, where is the fraud and dishonesty?
My lord, the question here comes is that the misconduct in during the course of the
Exactly.
service.
So misconduct has to be correlated with theft. That is the only allegation you have.
No, my lord,
Unless you say that he was guilty of theft, it may be at least you say it was unauthorized connection. There has to be a finding.
my lord, may I just come to it, my lord? My lord, may I just see there are two charges here. The breach of ASAB officers conduct regulation.
Hmm.
There's also the conduct which was been imposed upon him. That conduct was a misconduct, my
This
lord.
conduct, this charge 2 is with reference to charge 1.
Yes. So charge 1 is that, my lord, that there was a charge of theft. And my lord,
Theft,
even
you
if
can't
there's
bring
no
in theft now.
yes, my lord. Absolutely, my lord. If my lord is checking in the inquiry report, even if there is no theft, so there is an unauthorized use of electricity. And even if the unauthorized use of electricity is there, that has been a fraud, my lord. Because
What I'm saying, that
Yes, ma'am.
unauthorized use of electricity
yes, my lord.
under the rules, under the regulations, is there a provision? Is it mentioned what is unauthorized, what is authorized, what is theft?
My lord, the section 126 talks about the Indian District Court also
Let
unauthorized.
us see 126 Electricity Act.
use. 126.
One
126 will not be, my lord, that will be not for.
One 127 is appeal.
My lord, assessment under this section shall be made equal to for the purpose of at page 72, my lord.
Yes.
Explanation for the purpose of this section. At B, my lord, unauthorized use of 72, page 72, my lord, 126, clause 6.
$72.
Yes, my lord. Section 126, page 72 it will be. My lord, if my lord is having the same copy. Section 6, 126, subclause 6, subclause B. Under assessment, my lord.
Hmm.
My lord, for the purpose of this section, my lord, at B, my lord, unauthorized use of electricity means the users of electricity by any artificial means, by a means not authorized by the concerned person, authority or licensee, through a tempered meter, for the purpose other than for which the users of electricity was authorized, for the premises or areas other than those of which the supply of electricity was authorized. So, my lord, he categorically falls under the unauthorized use of electricity, my lord.
No, so what is the procedure prescribed?
Now, the further procedure prescribed for the unauthorized use of electricity is that
You'll have
after
to make an assessment.
you have to make an assessment.
Uh.
But my lord, here the main thing is that there was a disciplinary proceedings against the officer here because he had taken unauthorized use of, he had taken
That's what I'm
electricity.
saying.
Yes, my lord.
To establish a charge of unauthorized usage of electricity,
Yes, my lord.
once you come to a finding that it was unauthorized, under the act, you are required to make an assessment.
My lord, that would have been a different proceeding altogether.
Maybe, but it proves, it supports your claim that it was unauthorized.
No, may I just submit it here, my lord? My lord may just see here that
He denies the allegations you have made in
No.
his WS.
No, my lord, may I just come, my lord, whatever the petitioners, my lord may just hear me out, if my lord pleases, my lord. My lord, what has happened here, there was an inquiry. First, there was an inspection. In the inspection, we gave a sheet. In the sheet, it was come to the, that there has been an extra sanction load that has been to the petitioner. We inquired, we tried to find out that whether the petitioner had taken any kind of temporary connection to his premises. It was not found. Before that, my lord, there was another inquiry had been held. After the inquiry being held, we took independent witnesses and thereafter we came to the conclusion that yes, there has been some kind of illegality that has been conducted. Thereafter, my lord, we gave him a show cause notice. That show cause notice, my lord, he gave an explanation. In the explanation is at Annexure 46. My lord, before that, I would like to take to page Annexure 6 once, my lord. Page 45.
Yes. Yes.
Report submitted by CVO dated 30/10/2014 revealed that during the incumbency as CEO Golaghat, you had misused your official power as CEO by taking advantage of official status, complaining your subordinate staff, namely Navajit Thakur Sahayak and Laurent Chutia Sri Sahayak, to draw illegal service connection in your residence situated at Kayapati, Gujarat. The misuse of power created reinstatement among the public and became a subject to the criticism. You are asked to explain why did misuse your official power for wrongful personal gain and did cause loss of revenue to the company. So, my lord, this was a report in 2015 that was after the pre-inquiry that has been done with regard to the situation that had arisen in Gulhargat at that time. For that, my lord may go at Annexure 5.
So what is his reply?
My lord, I'll just come to it, my lord. I'll just come to it, my lord. My lord, before that, my lord may just see here. Observation at page 44, just a page before. It is observed from the inquiry conducted in the matter, including the statements above noted person, it transpires that Abdul Rashid so-and-so, by taking advantage of his official status, compelled his subordinate staff, namely so-and-so, to draw an illegal service connection to his residence situated at Kayapati. The misuse of power created reinstatement among the public and became a subject of criticism of the officials of APDCL by the public. It would perhaps appropriate to mention here that the entire matter was in public domain and there was a big commotion amongst the public of Golaghat since the role and function of Abdul Rashid widely circulated through a local daily newspaper, so-and-so, and other newspaper. Now the finding, my lord. The inquiry conducted by my predecessor, the statement recorded by him, including the existence of photograph in the file showing existence of welding machine in the house of Srirana, existence of photograph showing drawn of an illegal connection, and the statement recorded by so-and-so gave a strong indication of an illegal act committed by so-and-so. There is enough prima facie evidence exists to register a criminal case against Abdul Rashid for conducting a thorough investigation for local conclusion of this matter. It is also suggested that a strong disciplinary action may perhaps be initiated against Rashid for his extreme misuse of official power including loss of revenue to the company and demeaning the.
Where is the proof?
Yes, my lord. Now we have,
These are allegations.
no, these are the
These are allegations.
no, my lord, these are the first pre-inquiry and thereafter, my
What
lord.
happened to the earlier CVO report?
No, this is the earlier CVO report, my lord,
No,
the first CVO report.
No, you read the page 43, opening lines.
Yes, my lord. The inquiry conducted by previous statement, including the existence of photograph in the file.
Page 43,
Yes, my lord.
opening lines.
As per your order in continuation of the inquiry reported by my predecessor staff along with, my lord,
So
this,
there was another inquiry report.
my lord, my lord, this is not the inquiry with regarding the disciplinary proceeding. This was inquiry.
You are referring to it.
Yes, my lord, I am referring to it because the entire time the petitioner had been suggesting that has been two inquiries. What I'm saying is that this was with regarding the fact inquiry, fact finding authority.
Exactly. Prior to that, there is one more inquiry.
Yes,
Where is that?
my lord, that has not been annexed in the petition, but that was only with regard to the fact finding, that whether whatever the situation that happened on,
This has no relevance.
my lord, this
This
has
has
a
no
relevance.
relevance
My lord,
after
there-
the inquiry you have conducted.
My lord, there is a
This is a
relevance.
preliminary inquiry.
Yeah, this is a fact finding inquiry, my lord.
Then-
There is a relevance. I just want to bring it to my lord. So, my lord, thereafter, my lord may see his explanation to the fact finding, my lord.
Hmm. Yes.
My lord, at page 47, second line.
Yes.
I also reported to the CGM about the situation and role of it, about no remedial measures were resulted. On going through the records available with the report submitted by CVO, I found that I being unnecessarily drawn to an allegation which is nowhere related to me. Controlling of activities of line staff and FME within the jurisdiction of subdivisional matter. Any inaction in the part of this respect, not taking an action timely against an allegation of the lapse of the. It is found that the report of the CVO is based on statement of line SD, but not on physical evidence.
Then?
But it is felt that a pre-assumed advance inspection against might have influenced the report of CVO. I have never called any line staff. This is his, as he has been given a reply. After he has given a reply, we gave him a charge sheet. That is at page 2015, where we have said that there's a theft, fraud and dishonesty in connection with the business of the company, and there's a breach of ASAB conduct and regulation. Now, my lord, after the allegation or statement of allegations, the charges were framed and the charges were broadly explained. Now, my lord, I would like to take you to the second page at page 49, my lord.
Yes.
Charge 1, theft, fraud, dishonesty. The report submitted by CVO revealed that, and then
Mr. Sharma, we have gone through this.
yes, my lord.
Yes,
The
you
photograph
tell
of the
us,
file
you
show-
tell us
Yes,
how,
madam.
by reading the inquiry report, on what basis the charges have been proved. More particularly, when you have dropped the charge of theft.
My lord, that is where I was coming to, my lord. My lord,
If
may
you
this,
prove charge number 1, then the question of coming to charge number 2 will arise. This is one. The second is, petitioner himself says that as on date, he's not very concerned with what charges have been leveled against him because he's already crossed the age of superannuation. His only grievance is that having there being no finding about any loss being caused, whether you can recover the gratuity.
my lord, may I just, I'll have page 75, my lord, PW4.
Yes.
Deepak Kumar Das, AGM APDCL, my lord.
Mm. Yes.
Where it has been said that on examination revealed that an acting on a complaint along with a photo and newspaper clipping, the CEO elect Gulaghat Circle had taken a hooking line. In addition to his authorized connection, they went to Gulaghat headed by CVO for inquiry. With local carried load survey in residence of Sri Rasid and detected a load of against sanctioned load connected 1 kilowatt and asked SJ to raise assessment bill. Illegal hooking connection reportedly dawned to residents Sri Rasid was not seen during inspection. Statement of Sahayak Navajyoti Thakur divulged that he with Sahayak Lankeshwar so-and-so drawn on additional electric line in house of in the presence of being asked by the FME Kiran Gogoi and GST1. It was drawn from L pole to his house. On examination of Sri Rasid at the bottom, my lord, that additional line seen in photo was actually drawn to a house consumer residing near the house. Neither name, not any convincing reply could be given as to why said BP line was removed suddenly. So he has never said that there was no extra connection to my line in the inquiry report. On examination, Sri Rasi defended that additional line seen in photo was actually drawn to the house of BPL consumer residing behind his house.
So where,
Neither name, not any convincing reply could be given as to why said BPL line was removed suddenly. So he first said that there was a line that's gone to the BPL line that is behind his house. And then why was it removed suddenly? So my lord may see here that there has been a line and he has said that
he
yes,
did
there
not
was a
say
line.
he has drawn the line. He says some consumer.
No, he has said
Uh,
that was actually drawn to the house of BPL consumer
who's that BPL consumer?
residing behind his house.
Exactly.
And there was no name that was given by him. There's no name provided by him. Never, or nor in his any of the statement he has said this, that there was some other person who has been there residing in a BPL consumer.
So therefore,
So my lord, there was
therefore,
yes, my lord.
what ought to have been done by the APDCL was to make the recoveries by way of assessment for causing loss. That was never done.
My lord,
That was never done.
that was as of now, my lord.
Now you want to recover it from his gratuity
No, my,
without any finding that what was the loss caused.
no, my lord. In that point, I would like to come to my lord. I would like to read out a gratitude once again to him. But before that, my lord, may just see here that now the page 77, my lord, the finding.
Now you have referred to these documents.
Yes, my lord.
Page 77.
Yes, my lord.
What documents? What does this document say? What is there?
My lord,
Who
if
has proved it?
my lord may give a date to me, I'll bring on this on I'll bring the entire file here, my lord. But my lord, I'll bring this entire file. My lord may just see there, the bottom, during inquiry office, the inquiry charge officer is given ample scope and full liberty and natural justice to possible extent in every step. He is allowed to cross-examine prosecution witness in which is avail, and also allowed produce defense witness if any speaking in his favor. But he could not produce and he's examined only defense witness in the proceeding. So my lord, he did not, for his
Did you
charge,
appoint any presenting officer?
yes, my lord. Then we have, there's an order here into that regard, my lord.
There is no mention in the inquiry report.
About what, my lord?
The presenting officer.
My lord, this was inquiry has been done as per the order, my lord. Has been clearly, there has been no order that has been attached here also, is my lord. My lord may see here.
Can certainly take a ground that the rules do not prescribe.
Presenting officer, my lord may see page 63, my lord. Next date is fixed for examination on presenting officer is requested to inform, look, 63, my lord. My lord, it's been there, my lord.
Nope.
My lord may see from 61. The inquiry officer being appointed and Sri SM Sharma has been,
Now coming to the,
my lord's question, my lord, with regard to presenting officer.
no,
It's
no,
my-
all right, presenting officer you are appointed.
Yes, my lord.
Now, the counsel for petitioner has referred to clause 4(6). That these are the circumstances under which you
I
get
apologize, my lord, I could not get, my lord.
clause, section 4, clause 6 of the Gratuity Act.
Yes, my lord. Notwithstanding anything contained in
He says
subsection.
that it is only in these circumstances
Yes, so
that
my
you can
lord,
go for recovery.
so my lord, they will, no, the gratuity of whose service has been terminated for any willful omission or negligence. There's a willful omission or negligence
All right, then
causing any damage or loss to.
where is it?
My lord, there's a comma after negligence, my lord.
No, correct, causing loss or negligence.
That means a gratuity, whoever has been terminated for any act, willful or negligence, causing any damage or loss to or destruction of property belonging to employer shall be forfeited to the extent of damages or loss so caused.
So therefore, you can deduct to supplement the losses caused by the delinquent employee.
So my lord, now,
So
if my
before
lord,
that, you'll have to come to a finding that what was the loss caused.
So my lord, in that respect, my lord may see, there's a checking report that has been given. And so my lord, if that part of the finding that is not there in the inquiry, that how much loss is theft is there, so we may be given liberty to look into that regard.
You look
Because
into-
my lord, whether there had been any loss or not, that has not been denied by him. He has never stated that he has not.
You have not you have not made the allegation that there is a loss caused. This is the loss caused because of.
My lord,
unauthorized
there could have
connection.
been two parallel proceedings in it, my lord.
Because you have dropped the allegation of theft.
Yes, my lord.
If you have dropped theft, then there's a question of you'll have to find out what is the law. It is unauthorized and not theft. Your case is it is not theft, but it is still unauthorized. If it is unauthorized, then an assessment has to be made to recover that amount.
Yes, my lord. Now, my lord, there can be another way of keeping into it, my lord. Now, the conduct of the misconduct that had been done, the word to the term as per the regulation, my lord, I'll just keep the regulation before. Now, whether this theft, are we indicting under the sections of the Indian Security Act or under the regulation of 10 of the service rule? That has been taken into consideration, my lord. This is the ASCB regulations, my lord. My lord, out page 12, internal page 12.
Yes.
Before that, my lord, just a page ahead, just a page before.
There are no
Disciplinary
pages
action and punishment, my lord, 10.1.
here. 10-1, yes.
Every officer of the board shall discharge the duties assigned to him with integrity, loyalty, and promptitude, and carry out all lawful orders of superior in respect of the work allotted to him. Without prejudice to the generality of the foregoing clause, the board may prescribe such rule as may be deemed justified, provided the act and omission listed below shall be treated as misconduct, theft, comma, my lord may get
Yes.
theft, fraud, or dishonesty in a connection with the business of the board of its property. So this disciplinary proceedings was with the allegations against this misconduct, that there was a theft, comma, there was a fraud, and there was an illegality. So it was not the scenario here that because there'll be a theft, there'll be a fraud. There can be a fraud
No, but
independently, my lord.
you'll have to establish theft, which you said this
my
allegation
lord.
is dropped.
If it had been like theft or fraud, or theft and fraud, I would have been obliged
You
with
are
my.
quite right. What we say, prima facie, there is no evidence.
No, my lord, there has.
There is no conclusion.
No, my
that
lord,
These actions have led to
fraud.
fraud or dishonesty or theft.
No, my lord, the theft, the inquiry of whatever the inquiry officer said,
This is
there's no theft.
exactly the query of the court. You see, if you have dropped theft, then perhaps it ought to have been replaced by unauthorized use. But you did not do so. You said, okay, we are not considering the allegation of theft. Having not considered that, now you are required to establish fraud or dishonesty.
Yes, my lord. Now that there I am, my lord. My lord, the inquiry officer says that there's inquiry report says there's no theft. But my lord, there is fraud and dishonesty. And how is it?
On
My lord,
what basis?
I'll show it to you, my lord.
Yes.
My lord may see my affidavit in opposition once.
Oh, your affidavit is supplementary. You can't bring it back. You tell us from the inquiry report
Yes, my lord. From the
or from the records available that records supplement the findings. From the inquiry report, you tell us that, yes, this was.
my lord, the finding.
No, findings have held,
Yes, my lord.
but the evidence, the manner in which it has been discussed,
My lord may
If you
just go
want to-
74, my lord.
if you want to
Page
rely,
74. Yes, my lord. Yes,
if you want to
absolutely.
rely on the
I absolutely get my
evidences
lord.
placed, you may
Yes,
do so.
My lord, page 74, my lord.
Yes. Yes.
Prag, PW2, my lord. Prosecution witness 2, my lord. Pragjyoti Datta, being SDE of Gulahgarh Electrical Subdivision 1, organized a survey on 9/9/2014, headed by Junior Manager, Technical Staff. Survey team detailed illegality and took departmental action under DTR 606 located at so and so. Thereafter, my lord, at bottom, my lord, line staff confirmed him about said connection, which was made on 27/7/2014 Sunday. On 24/9/2014, a team headed by CVO from APDCL came to Golaghat and carried out inquiry on this suspect. Inquiry team detected connection load 4 kilowatt in house of Sri Rasid, but in the office record it was 0.9 kilowatt. Basing on the report, SD Golaghat took up
That is a different aspect.
My lord,
That is connected load and sanctioned load.
no, my lord,
This is not unauthorized.
no, my lord, the
Yeah.
connected load can only be increased.
No.
No, my
Not
lord.
necessary.
No, my lord, this is not, my lord, may just see here, my lord.
You look into your regulations, how it is calculated.
My lord, may just,
Connected load and sanctioned load is on a different issue. Here, the allegation is he has used means to have unauthorized electricity by having a, what is that, connection, service
Yes.
line.
yes, my lord, even the inquiry officers report and the page 74 and page 35, they coexist, but they cooperate with each other, my lord. My lord, the sanction load, my lord may see connected load 0.9 kilowatt. So why would, my lord may see page 35 once, my lord.
Hmm.
My lord may see here, Abdul Rasid, same C on a DTR number, load connected load is 0.9, meter details, first install meter so and so, second meter so and so, extra service connection was as found from the pole without meter as hooking. Photograph will speak the truth. Now assessment bill to be prepared with the fact of connection as stated by the line star for 12 months. Please be confirmed in this case. Provisional assessment bill against load so and so on the basis of unit consumed in terms of consumed volume and also prepare for further checking and approval to send the same to the consumer so and so. Now this correlates with the page 74 and also correlate with the affidavit in opposition where he has paid the bill, where he has accepted it. My lord, may just see
So
the.
if he has paid the bill, then why are you trying to recover the?
No, my lord, it's not, my lord, there are two different stances here, my lord.
Ah.
My lord, first is whether as per the regulation 10, whether there was a theft, fraud, dishonesty. With that regard, my lord, there was theft, there was fraud and there was dishonesty. My lord, may just see page 16 once again. Annexure.
Therefore, you have compulsorily retired him. Now you are trying to recover the gratuity. If the amount has already been recovered, why have you recovered the gratuity?
No, my lord.
Contrary to the provisions of the Act.
My lord, the what he had, my lord, may just please, my lord, I refer my lord, my lord just may have a look upon annexure 2, page 16 once, my lord.
You tell us from the statute.
Yes, my lord.
Tell us from the section 4 of the Payment of Gratuity Act. There appears to be a bar.
So there appears to be a bar if there is no damage to it. So now I'll prove that point to you how we have incurred. My lord, may just see annexure 2, page 16, my lord.
Hmm. (16)
16 of annexure 2 of my affidavit of opposition. Continue, page number 402. My lord, an index has been given for my lord.
Yes.
My lord may see here, report about payment of AB access against load. With reference to subject matter and telephonic construction, I have honored to submit the following information sought. Name of consumer, Abdul Rasid. Access load 3548 kilowatt. Assessment bill served so and so. Amount paid so and so. Load security so and so. So if he had not taken the extra load and if he have not taken the illegal, the temporary second connection, then why did he pay it?
Quite right. Then why are you recovering again from
No,
gratuity?
my lord, now this is, my lord, this is where, my lord, the thing is, my lord, what we have taken, we have only taken the amount paid and we have only taken the load sanction payment.
Huh.
Only the load sanction
That
payment.
is your problem. Why did you get him away, let him go away without paying the load which was not authorized? That is what I was trying to tell you. Sanctioned load, connected load, that has now been regularized. But the theft which you have alleged,
My lord.
see, there are two ways.
Yes, ma'am.
Your arguments are subject to correction, are self-defeating. You are saying that theft is different, this is one proposition, theft is different, connected load, sanction load is different. If connected load, sanction load is different, then that gets regularized by making this payment,
My lord,
analyzed or whatever.
may I just rephrase, my lord, what I am submitting here, my lord? I'm submitting this, my lord,
Hmm.
that first when the inspection was there, we found that there was an excess load.
No, there is no confusion there. What we want
My lord,
to
I'm
be
just,
clear about your submissions, is it your case that because there was a difference in connected load and the sanction load, it amounts to unauthorized use? And therefore, that is dishonesty, fraud, etc.
my lord, as
Or you want to say that besides being a difference between connected load and sanction load, there was also the allegation of taking unauthorized electricity by unauthorized service line.
my lord, that is what I'm submitting, my lord, that there, even though there was a, my lord, we are here, he's challenging here the departmental proceedings here, my lord. He's not here, he's not challenging that I have not taken assessment load. So we have conducted inquiry under him, under regulation theft, if theft, fraud or misconduct is there. There, the first allegation was there, whether there was a line going through your house, which was not properly executed. That has been found. The material has been found, and even he has accepted it by paying the excess load. My lord, I'm just coming to it, my lord. What my lord is coming. Now with regard to
That is what I want to know.
Yes.
This excess load amount which he is paid, is that excess load is with respect to that unauthorized line?
no, that cannot be, no, my lord, because because my lord, the period of he using the line,
Hmm.
period of how many days he's been using the line, and the assessment that has to be done independently by now under 126. That has
Not been done.
that we have to take leave from this court to do it.
No, you
If
don't
my-
have to take leave. It is your call. That has not been done.
that my lord, I am fair to
So
this court.
unless it has been done, that means you have not quantified the loss cost
My
because
lord,
it was not done.
my lord, the
If it
quantity.
was not done, then the apparent bar under section 4(6) comes into play.
My lord, let me just rephrase it once here, my lord.
We have understood. You don't need to rephrase. We want you to understand and come back with answers if you want.
My lord.
You tell us that what is the loss cause. You answer he has abandoned all the other grounds. He has relied upon section 4(6)
With regard to the recovery from the category.
recovery, because you have not quantified the loss. You say that guilt of the petitioner is proved because he has made payment for the excess load.
Yes, my lord.
Now, if excess load is paid, means whatever losses are caused has been taken care of by
No,
him.
my lord. The excess load would only give a payment to that structure that the load he has been sanctioned, that has been taken. But the amount of electricity bill he has consumed, an amount of the electricity that has been.
That you have not taken.
My
You have
lord,
not proceeded against him.
my lord, there was an assessment done. There was a report being done, but assessment had not been done. That I fairly
That-
submit, my lord.
that-
That has not been done here.
So if it has not been done, that means you have not quantified the loss.
So, my lord, for that regard, leave may be given by this court.
Why should we give you leave at this state? You have conducted the inquiry. You have abandoned the ground called theft.
abandon
You have not come to a finding that yes, there was theft.
My lord, that's the inquiry. The disciplinary
The
authority found that
disciplinary
there was no-
authority, the appellate authority, nobody said that no, yes, there was theft.
but there was a fraud and dishonesty, my lord.
Could be.
Yes. So for fraud and dishonesty, the punishment was given first.
Yes, but then you can't impose recovery under gratuity unless you quantify the loss.
One thing your lordship has pointed, but still I want to clarify, my lord. What my learned friend has understood, that is not correct. 135 of the reply, my lord. Can you see?
135?
Repeatedly, he is submitting
135
of my lord, page, his reply, my lord, their reply, page 16 would be internal page. He's reading it, my lord, time and again, my lord. This is what that just now he read, my lord. Annexure 2, my lord.
Annex page 16, my lord, of the affidavit in opposition.
That I made payment and all, my lord. He's saying.
Hmm.
My lord, this is what has happened, my lord. The witness has clearly said when they have gone for assessment that extra line was not there. But going to my residence, they found that in my residence there are some extra load. It may happen, my lord, in my house there may be 10 kilo load. When the ACB authority come and check up, they might 15, then 5 load, 5 kilo I have to pay extra. This has nothing to do with the misconduct of the charge, my lord.
That is what we said.
Yes, my lord, we have said, my lord, time and again, my lord. What he's saying, my lord, I made payment. This is regarding my extra load in my house.
So
This
he
is
says that this extra load that you have been taking
This is not the charge, my lord.
is misconduct because you are an officer of the
No,
board.
that happens in my house also, my lord.
No,
Earlier
your house maybe, but you are not employed under the ACB.
And this is being clarified by witness page 74, my lord. 74 clearly say, the witness clearly says that when we went there, the extra connection was not there. Or when we checked
Extra
up,
load was there.
no, that connection was not there.
But
Extra load in the house was
you
there.
have more connected load than the sanctioned load.
That when I found that there is some extra load, maybe Gizar, AC, whatever, I paid.
My lord, nowhere in the inquiry report, the inquiry report clearly says that inquiry team detected connected load of 4 kilowatt in the house of Sri Rasid. But in the but in the office record, it was 0.9 kilowatt.
Yes.
So the connected load was already there. So he is saying that he is never used. How can that be, my lord? When the
I'm not
connected-
saying.
So you are not clear about sanctioned load and connected load. You get your instructions. there.
No, my lord, this is not.
Sanctioned load and connected load has got nothing to do
No, my
with
lord, this is not
unauthorized theft.
section load or connected load here. My lord,
That is the finding.
no, my lord, may see 74 once, page 74. Page 74. There is
Yes,
no
my lord. 74, my lord. I'm reading, my lord.
page 74.
Yes.
It has been clarified.
Inquiry team detected connected load of 4 kilowatt.
You are reading from,
Connected load.
you
My
are
lord,
reading from
prosecution witness 2 at third line, my lord.
page 74.
Yes, my lord.
Yes.
Inquiry team detected connected load.
Yes.
4 kilowatt in the house of Sri Rasid.
That's
But
right.
in the office record, it was 0.9 kilowatt.
Exactly. That
So,
is
my
what we are saying. Your connected load, sanctioned load aspect is a different compartment. The allegation which you are making of having an unauthorized line from the pole is on a different compartment.
My lord,
Whether he is having more connected load than the sanctioned load,
My lord.
whether it will be misconduct or not is a different issue. But to say that this proves theft by way of an unauthorized line is not correct. Subject to,
And this is not the charge, my lord. That's the reason, my lord. This is not the charge,
my lord,
this is what your act says.
my lord, the entire facts of the case is this, that without being authorization of a temporary line, there was a line that was found.
We agree with you. We are
Yes.
with you there.
Yes.
What your people have found out is that there was no line when they made the inquiry.
Yeah.
But instead, when they made the survey within the house, they found that the connected load was higher than the
Yeah.
sanctioned load. This does not ipso facto explain that they were using an unauthorized line.
My lord,
This
may-
only means,
on that regard, my lord, just see page 75, the finding number 2.
yes, 75,
Yes,
finding number
2
of,
of the page 78, my lord.
yes.
The petitioner had obtained a sanction load of 1 kilowatt and connected data of 0.9 in year 2006 at his residence. On 24/9/2014,
How is
My lord,
connected, how is connected load calculated?
No, my lord.
No, please tell us how is connected load calculated?
My lord, I have to get through it. My lord,
No,
see-
yes, that is
My lord, there has been-
therein lies your answer, Mr. Counsel. Please listen to the court.
Yes, my lord.
Please tell us the formula how connected load is calculated.
Yes. My lord, that's 6.1. I'll get there. My lord, may I just hear that the detected connected load in his residence, neither subdivisional officer carried out load survey nor Rasid brought the issue to the notice of concerned official for long 7.5 years, causing loss to the company. So for 7.5 years, he being the SDO, there was a connected load that has been used more than.
Being argumentative without proper instructions does not reflect properly on the counsel. You find out what is the formula in connected load. you will find your answer to the query put by the court.
My lord, my lord, what my
You are
lord,
insisting that this increase in connected load is because of theft.
no, my lord, I'm not submitting that, but what am I submitting is this, that whether there was the load sanction and the load connected, my lord,
We agree with you. That is a finding. He has paid the money.
yes, my lord,
So you want to say this is misconduct, agreed.
yes, my lord,
No difficulty.
yes, my lord.
Now you tell us what is the loss caused
My lord, for
because
that,
of
I'm,
which you are seeking to recover.
no, for that, I'm fairly submitting before my lord that the assessment under 126 has not been done.
Right.
Yes, so that leave may be given to us. That's what I'm seeking for.
What leave?
My lord, to calculate the assessment and the amount
No,
of
but
loss.
then before you calculate, how can you pass an order for recovery?
My lord, that recovery that has been done was based on this ample thing that the amount of the what been consumed. So my lord, on that regard, I would,
That has already been regularized. It is your finding, your statement. Your affidavit has enclosed that. You have regularized that. Had he not been an officer of the board, you would have imposed penalty as you do in normal customers.
my lord,
But because he's an officer, you have given him the liberty to just regularize the payment and get away with it.
Yeah.
Other ordinary mortals would have been begging before the APDCL to remove the penalty. But this is besides the point. You have removed theft. There is no finding that he has caused loss. Now, under what authority do you recover or seek to recover the gratuity?
my lord, may I just submit just once before my lord part of the record. My lord, we have a sanction load and we have a connected load. So once for excess load, we go and pay up amount. to the AP.
You're getting back to the same thing, Mr.
My lord,
Counsel.
I would drop this point to you, my lord, by giving my lord may.
You get
Give me
your
an opportunity.
instructions clear. You're not clear on the assessment of connected load. You're not clear.
My lord, I would get clear on that, my lord. If my lord give me a date to find it.
My lord,
You first tell us on what basis you are attempting to recover gratuity.
My lord, I would get on that point, my lord.
Yes.
Lordship, can you see that regulation for a moment, madam? What can regulation, madam? That one 10, clause 10, my learned friend has relied, madam.
Yes.
Here it says that, my lord, what are the misconduct? To B, my learned friend has read, my lord. Lordship, can you see C?
Hmm.
Causing willful damage or loss to the board's goods or property. This is the misconduct, my lord. Now, Lordship, can you see the punishment? Next page. What are the punishments for this, my lord? Warning, reprimand against the misconduct, my lord. Number 5, recovery of loss caused to the board. So first they have to quantify the loss, then recovery, my lord.
You are reading.
That clause 10 itself, my lord. Regulation that has been regulation 60, my lord.
So after J comes K, I, all that. Page number 13.
Clause 10,
Page number 12 is clause 10. You're referring to clauses A and B. A, B,
10
C.
A, B, my learned friend has read, my lord. C,
You're
I want
referring to C.
C.
Then
C is a misconduct causing willful damage or loss to the board. So
Yes.
loss is mentioned, and then penalty. What penalty against loss, my lord?
Hmm.
5, my lord.
Hmm.
1, 2, 3, 4, 5.
reduction to a lower post.
Recovery of loss caused to the board, my lord.
It's not here.
It's different.
This is different.
The punishment, my lord, punishment.
Punishment is without prejudice following penalties. If you are found guilty of misconduct.
This is the one. Intent of violation.
My lord, this is not. This
It's not even there.
Yes,
It is not even there.
this is from internet, possibly that's not tallying with them, my lord. But it's not available in the. That's why.
But your punishment of termination or compulsory retirement is there.
It's there. So, my lord, only one clarification, my lord. The recovery has not been directed only against gratuity, my lord. even 1/3 of my pension, my lord. So both, my lord. There being no loss alleged
Okay, heard.
or quantified.
Learned counsels for the parties. Yes, you tell us. Then you can get it. 12. Oh, sorry. 10.
My lord, can it be on 12th? I'll get the instruction by then.
Let it be on 10th. 10th October.
What's up, man?
Heard when it was when? It's on 10th. Yes. These are punishments.
Lordship, subsequently it is modified to reduction of increment, Lordship. Earlier it's removal from service, but subsequently it was modified.
Who's for the petitioner?
Mr. R.S. Sohan. All are connected matters,
All right, time being.
Lordship.
Time being.
Time being the matter.
Time being. Yes. What?
Lordship, kindly, this matter may be taken next week, Lordship.
Why?
Lordship, the counsel for the item is the item made with an accident, Lordship. So
Counsel for
the item is
petitioner.
a petitioner, Lordship.
What is the name?
P. Gogoi, Lordship.
It is submitted that counsel
Lordship.
for petitioner.
Lordship, it is also listed in the regular hearing post list, item number 4, Lordship.
All right, we'll call it up. Item 6 be called up in next week. Next week. This matter was heard. Then
Lordship.
why was it deferred?
My lord required certain clarifications and the hearing was not concluded, my lord. Unfortunately, my lord, I was also not there, my lord, when the matter was heard. So the matter has come back before. Basically, my lord, with regard to upgrading of an ACR, expansion of it was a below marked ACR.
Just 1 minute, 1 minute.
Lord, if your lordship is hearing it afresh, let it be after vacation.
No, this is the problem. We don't want to keep matters parted because if it gets too elongated.
My lord, I understand.
Further hearing.
What was the issue here?
My lord, issue here was there was an ACR for 2010-11, wherein, my lord, he had got 1 mark less than the benchmark. I had approached this honorable court. This honorable court, my lord, on evaluation of the matter.
His earlier ACRs and everything were
were
right.
top, my lord. Only this was brought down. Then this honorable court, my lord, asked me to file a representation and they to take up the matter. My lord, they took up the matter on perverse conclusions have come to the conclusion that, my lord, Powers grounds have come to the conclusion, my lord, that it is okay. Thereby my promotion, my lord, was with her. And my lord would see only 1 mark is required, my lord, and 59, I should get 60. And from the ACR itself, I can show, my lord, how the markings were given. It was deliberately done to, my lord, bring me down.
So what is your status now? I mean,
I have retired, my lord.
you've retired.
If I get this, I'll be having some monetary benefits.
You are not ready to conduct the hearing today.
Lord, it will be better is after vacation. My lord. In fact, my lord, I came last night from Delhi. My lord, I could not go through it.
2015 matter, Mr. Dotson.
Yes, yes.
Yes, Mr. Nair.
Before
No,
the
the
vacation, my lord, we
only-
can take a try. If otherwise, then we'll go after the vacation.
What is the only issue here is
That
his
ACR.
appreciation of that
That
particular
is-
ACR.
the
Exactly.
particular ACR. And the grounds that were given, my lord, while rejecting my prayer. Pleadings are otherwise complete.
Let us, we'll accommodate you for today. Let him proceed with the hearing.
Yes, yes.
And
That-
then on some other convenient date, you can give your
Might-
reply.
Okay.
Because otherwise it's a 2015 matter. So
Right.
we don't want to, deferring it means we do not know in which docket it will go in.
I'm conscious of that.
Just 1 minute.
Lord. My lord may have the.
Just 1 minute. Yes.
My lord, just the background.
Huh.
He joined as a probationary officer in United Bank,
Yes.
my lord, in the month of December 1985.
Yes.
Thereafter, my lord, he was promoted as a middle management grade scale 2 officer on 27/3/95. Thereafter, my lord, middle management grade 3 on 5/10/2001. In 2009, to be precise, my lord, 24/12/2009, he was a senior management grade scale 4 officer. The next avenue is, my lord, assistant general manager scale 5. What had happened, my lord, in the promotion policy, there is a requirement that there should be 60% marks in the APR in the years under consideration. And thereafter, 50% marks will be taken from APR and 50% from group discussion, interview, etc. for that selection for the post. My lord, I cleared everything, but I was not called for the interview. I instituted WPC 3362/2012. This was, my lord, therein they came and they disclosed that because I did not get 60% in my APR for 2010-11, and that is why, my lord, I was not promoted. The APR was not communicated to me. The series of decisions in Devdutt and all were not complied with. Thereafter, this honorable court, my lord, on WPC 3362 was taken up for hearing, and on 11/8/2014, this was remanded back to them, asking me to make a representation against that APR. I make a representation, madam.
Where is that order?
My lord, that order, my lord, would find at page 109, my lord. The relevant would be, my lord, starting from page 111.
Yes.
My lord would have the relevant from para 18, 117.
Yes.
Though the learned counsel for the petitioner had argued both the issues, validity of the circular dated so-and-so as well as the non-communication APR for the years under consideration to the petitioner, court could discern more emphasis being laid on the second issue. Maybe because of the legal position governing the second issue has been settled by the Supreme Court. As a matter of fact, learned counsel for the bank in course of his argument had to consider the legal position on the second issue based on law enunciated by the Honorable Supreme Court, though he vehemently argued on the validity of the impugned circular, that is the first issue. That being the position and the considered view that it would make things of justice if adjudication of the list is confined to the second issue or the second ground of attack of the petitioner as a decision rendered on the second issue would be an effective resolution of the dispute. On the second issue, facts are not disputed. Bank had considered APRs of the officer for 2 years for the year 2010.
So there is a finding that it is contra Devdutt and other judgment.
Lordship.
My lord would have para 24.
Yes, yes.
The court is of the considered view that the procedure adopted by the bank in excluding the petitioner from consideration of the promotion to so-and-so is not in conformity with the law laid down by the apex court as noticed above. Devdutt and all were noticed, my lord. Petitioner was considered ineligible because his APR grading for one of the 2 years, 2010-11, was below 60%. Yet the APR remarks were not communicated to the petitioner, though as per law declared by the Supreme Apex Court, all the APRs were required to be communicated to the petitioner. That being the position and having regard to the law laid down by the Supreme Court, following directions are hereby issued. Entries in the APR of the petitioner for the year 2010-11 and 11-12 be communicated to the petitioner within a period of 30 days from the date of receipt of a certified copy of this order. Petitioner may submit representation before the bank against such entries within 30 days from the date of receipt of communication of the entries in the 2 APRs to him. Such representation shall be considered by the authority of the bank, who is placed higher in office than the accepting authority. Consideration of the representation should be done fairly and objectively with an open mind by the higher authority within a period of 2 months from the date of receipt of the representation. Decision taken on the representation shall be communicated to the petitioner. Once the above exercise is completed within the period specified, and if the petitioner attains eligibility, bank shall hold a review DPC to consider the case of the petitioner for promotion to senior management grade scale 5, along with the batch of the respondent number 5 to 49 within 2 months of completion of the exercise.
Did this go up in appeal?
No. This,
And then the impugned order at page 123.
the impugned order, my lord, would find page 152.
122.
152.
152.
My lord may have.
What is that 123?
123. My lord, they had forwarded the APR to me.
Okay.
By this, my lord, 11-12, I have no grievance because that is 95 marks. So the next page, my lord, would find the APR 124 for 2010-2011. Now the marking starts at page 127 onwards. My lord would see
How many years of APR are required?
2 years they take.
2 years.
10, 11, 11, 12. 11, 12, it's 95.
No, as per the rules,
2 years, man.
2 years are to be considered.
Consider.
So under the Devdutt law,
Lordship,
if it was not communicated, could not have been taken into account.
consider.
So in that event, what happens? Is there an earlier year?
They'll have to give me that APR and I'll have to make a representation, then a authority higher. Then the accepting authority will consider it. And if it is then, my lord, upgraded, then I get the consequential promotions or whatever it is.
No, that is a challenge to the APR.
Lordship,
What I'm saying is, you are aggrieved initially
lordship,
by non-consideration of your case
lordship,
contra Devdutt.
lordship.
Devdutt law says that in case you do not communicate, you cannot take that into account.
Into account. And there is also a provision there, my lord, that this APR, therein, my lord, it was said that this APR has to be communicated to me. And then I must be given an opportunity to make a representation against that. Thereafter, an authority higher than the accepting authority will consider. And if it is, my lord, thereafter, my lord, found that that APR has to be upgraded, then I get that promotional benefit.
Not otherwise.
Not otherwise.
Yes.
Here, my lord, would find the APR at page 127, the marking.
All right, markings we don't need. What
No,
we need?
that's what I was trying to show you, lord.
Okay.
One mark. Why that
127.
one mark is from that page itself, my lord, it's clear.
Hmm. Yes.
My lord would see, for very good, they had given me 30 marks. My lord has seen.
Hmm.
Satisfactory. My lord has got 6-6. Good 6-6. So good and satisfactory, they are putting it at one level.
No, satisfactory at the last also gets 7.
So if satisfactory is 7, why this satisfactory, my lord, is 6?
What is reverse?
No, my lord. Satisfactory is 7. Because 7 if you have given, that means you can go, you have that mark 7 to go up to, my lord.
It can also be reverse. It was given 6. So why 7?
6 is good, my lord.
No,
So satisfactory
before
is-
that. Before
No,
that.
my lord would see good is 6. So
Ah.
satisfactory is above that.
Sorry?
Satisfactory,
Oh,
having given 7, is above good.
no, that's all right. But
My lord wants
above-
it to be read the reverse way.
no, you see the quality of judgment and decision.
Lordship,
There also you're given satisfactory,
lordship,
where the marking is 6.
6,
So what I'm saying is,
lordship,
your argument that satisfactory is 7
lordship.
and not 6,
Hmm.
there is a contra argument that it should actually been 6, wrongly
No,
given to you as
Then,
7.
my lord, they will have to come before your lordship and satisfy your lordship on that. That we satisfactory and good are not the same. Satisfactory is above good, so we have given 7. Now, my lord would find at page 131,
Yes.
my self-appraisal, this is by the reporting authority, has been held to be reasonably accurate.
1 minute.
131.
No, there is 129. Yes. In our copy.
Oh, sorry, my lord.
So
It's said to be reasonably accurate. My lord has got it. It's overall assessment.
yes.
Reasonably accurate. Then, my lord, training needs accurate. The appraisee is a trainer now, hence no new for the training as sought for. So no need for the training as sought for. My lord will only keep this in view, my lord. Make a note of this because that will have some relevance with the rejection of that. So I was given 59. So it is 1 mark less than the required benchmark, 60. And now, my lord, let's see. My lord comes down below. Overall assessment, please tick. My lord has got it. they have ticked good, which is 65 to less than 70.
55.
65, my lord.
No, it says 55 here. Very good is 7 to less than 85.
70 to 85. 55 to 70. Okay, madam. 55 to 70. So that will come within that. Good. Now, my lord, I make a representation. That my lord would find at page 147.
Yes.
That is how, my lord, I was trying to deal with the various observations wherein marks were given to me. I'll not trouble your lordship with that. I will only have my lord's attention at 150, the last page of that annexure.
150.
150.
Yes.
My lord would see the different years how I have been. Leadership in 2006-7 was 75%, 2007-8 was 75%, whereas in 2010-11 it was made 37.5%. Then again, 11-12, 100%. 2012-13, 100%. This is how, my lord, they have marked me over the years.
Your promotion is for which year?
It will be, my lord, from 12-13, 13-14.
13-14.
Lordship.
So if it is 13-14, then APRs for 11-12 and 12-13 are necessary.
No, my lord, they
Sufficient.
have, I'll just place that, my lord. No, my lord, it's 12. 10 May 2012, that order.
So
had
it's
come.
12-13.
12.
So which
So
means
10,
10-11 and
11,
11-12.
11. Now the decision at page 152.
Yes.
My lord can skip that 152 and 153 till para. After the italic small quotings, my lord, the next paragraph also, my lord can quote. Please note that your aforesaid representation dated so-and-so has been placed before the executive director of the bank, being an authority higher in the office than the accepting authority for the purpose of APR of officers, employees working in scale 4. For taking a decision after consideration of the same in due compliance of the directions of the Honorable Guwahati High Court. According to the appropriate authority, has duly considered entries in your APR in original from 2006 to 14. My lord will only make a note of this one. This is the purpose. Pertaining to your performance as an officer of the bank in different capacities, marks obtained under different heads, under APR for achievement, your various heads mentioned in so-and-so, your independent assessment of your performance during impugned period, observation, special comments, so-and-so, against each entry in so-and-so, and after examining all relevant aspects related to reporting of your work performance during the year 2010-11, fairly and objectively with an open mind and disposed of your representation dated so-and-so by observing as follows. I have seen past performance and performance in the branch. Maybe in training college he has done good, but as branch head his performance was not so good. Marks allotted are fair and without any prejudice or bias. Now, my lord, when I was taking my lord through the APR, I had made a note, my lord, that when at page 129, when they were considering whether I required training, my lord, at that time, I was a trainer in a training institute under them. I was not working in any bank, any branch head. So that observation that they had seen my performance in the earlier years as a branch head, which, my lord, I was given very high marks.
Yes.
But at this point of time, I was working in a training college and it was said that my work is good. But as branch head, his performance was not so good and marks allotted are fair and without any prejudice or bias. I did not work even a single day during that period 2010-11 as a branch head. My last posting as a branch head was in 2009. July 2009. Now,
Yes.
the misrepresentation that has been made here, they say that they had before them my APRs for the year 2006 to 2006 to 2014.
Yes.
Now, my lord, what has happened is there was a proceeding wherein, my lord, I had made an RTI application. This matter went up to the Chief Information Commission, New Delhi. Therein, the bank had, my lord, on 4/4/16 submitted an affidavit. It's there in my reply, my lord. Submitted an affidavit wherein they say, I'll just read it, my lord. It was contended that in the said affidavit that the APRs for 2008-9 and 2009-10 were not available with the bank on 9/8/2014 till date, and the same could not be traced. It is questionable as to how on 11/12/2014 the two APRs were available for consideration by the appropriate authority to reject the plea for upgradation of APR. So when he says, my lord, he had all the APRs from 2006 to 2014 before him. This was, my lord, sometime in December 11, 2014. But when the matter went up to the Information Commission, my lord, it was said that these APRs were not available on record.
Meaning thereby?
Meaning thereby, my lord, that this statement is a false. It's just an omnibus statement made that they actually considered everything that was required to be considered. And the perversity is, my lord, that
under you applied under RTI.
RTI.
No, RTI.
Then
RTI.
various levels went up to the Chief Information Commission.
And why was it not available?
They only saw an affidavit that this is not available. Why it was not available, they have not disclosed.
Yes.
And the court only required them to look into my 10-11 APR, man, and 11-12. 11-12 I gave them, no need. But 10-11 they had to.
Where is the RTI reply?
My lord, that reply is not, my statement is there on record at internal page 6 of my affidavit in reply.
No, you're referring to some document.
Document. I can place that. I'll take all. If my lord can just have my reply for a minute, my lord.
1 minute.
If my lord can just have my reply, page 5, my lord. Say the pilot of the reply.
Where is the impugned order page?
My lord, 152.
Yes, what is it?
This is my rejection order. My lord would have page 153. The last two paragraphs.
Yes. Yes. I just
Accordingly,
wanted to know the page number.
153, 152 and 153.
Yes.
So, my lord, leaving aside everything.
Where is that affidavit?
That I have given, my lord.
This is okay.
The last page.
Why is it not available?
That they have not disclosed it. Fine. My lord would have the affidavit in the last page. There they have said that, but the reason is not.
Yes.
Now, the reasoning given for rejection is, my lord, only those two lines are required, my lord, to be looked into.
Yes.
153. I have seen the past performance and performance in the branch. Maybe in training college, he has done good, but as branch head, his performance was not so good and marks allotted are fair and without any prejudice or basis. From 2009 July, my lord, I'm not in any branch. So, and my lord would also have, for a moment, my lord, for my satisfaction, page 150, my lord, wherein that markings I had given.
Yes.
My lord would see for the all the earlier years and the subsequent years have been graded very high. This is a perverse finding. And in the writ petition, para 18. I think, my lord, this will, my lord, show the perversity. Para 18, page 21.
Yes. Writing.
Lordship. My lord, I have dealt with that remark. And the word used is branch head.
For which years are it?
2010 and 11. 2010-11.
Yes. Yes.
My lord, if I may just read para page 21, the last paragraph.
Yes.
A bare reading of the above quotation would reveal that the respondents, while deciding the representation of the petitioner illegally and arbitrary in a preconceived mind, considered his performance prior to the year 2010-11. It stated that in the year 2010-11, the petitioner never worked for a single day as branch head. Therefore,
Yes.
his performance as bank head cannot be the basis for any APR grading of for 2010-11 as decided by the respondent. In the year 2010-11, the brand petitioner was working as chief manager in regional office in Nagaon, and his achievement was excellent. In this context, pertinent to mention here that the petitioner worked as branch head up to July 2009, and thereafter was transferred to regional office, not a branch head assignment. And in December 2009, while being posted at so-and-so, got promotion from middle management grade 3 to management, senior management grade 4, considering his performance pertaining to the period as branch head. Be that as it may, after the promotion in December 2009, his performance as branch head cannot be used to his disadvantage in judging his performance in the year 2010-11. However, the impugned order was issued primarily basing on the performance of the petitioner prior to the year 2010-11, which is again a clear example of non-application of mind. Hence, is on this score alone, the impugned order is liable to be set aside and quashed. Their reply is an amalgamation of, my lord, para 15 to 26, and they have not denied this fact.
Yes. Okay.
9, my lord, para 9 of their affidavit, para 18, page 9 and 10, my lord.
Page number.
9 and 10, internal page number 9 and 10. And then my lord would have my reply.
Affidavit on 1 to 4.
1 to 4.
Manavendra Tiwari.
Lodge.
You're referring to page?
Page 9, my lord.
Page 9.
Para 18.
Para 18.
Lodge. The last paragraph. Now my lord would find the last line would be relevant. How they have done it. Because I have shown from the order that they have done it in a perverse manner. This-
Last line of?
That page 9, my lord.
Okay.
The appropriate authority disposed of, my lord has said,
Yes.
disposed of the representative of the petitioner by commenting that marks allotted are fair and without prejudice or bias, and after taking into account all aspects connected papers, records of past performance of the petition in the bank in different capacities, including branch experiences and submissions made by the petitioner pursuant to the judgment and order dated so and so. So, my lord, for 10-11, if they were writing my ACR at the very outgo, well, they were not taking into account my performances in the previous year. They will only go by the performance in that year.
10-11, you are not in the branch.
I was not in the branch. So that is the perversity there. And that again I clarified.
Yes.
In my reply in paragraph 12. (11) and 12. So, my lord, in this view of the matter, the direction of this honorable court for an unbiased appreciation of the remarks given in my appeal was not done. Now, my lord, it is clear from both the impugned order at page 152 as well as their affidavit para 18 that they had traveled beyond what was required. And my lord, the conclusions don't. My lord, let's give them that. My lord, they can travel. But if you travel and collect the actual facts. Because in the previous years, my lord, I had very good APRs. 75% leadership skill. 2011-12, 95% total. You, for the purpose of rejecting it, come to a conclusion that no, we will not give it. We will give him a remark like this so that it can be done. And my lord, they have succeeded. Because this remark has now, my lord, practically destroyed my that avenue of promotion. Or I would have been in that position, my lord, while I was in service. Now I am only entitled to the, my lord, would be entitled to the, if my lord allows it, to the, my lord, benefits of financial benefit. Actual thing, I was deprived. And they deprived knowingly. This is my humble submission. Move it. And if my lord takes up the APR in itself, my lord, therein also my lord would not find any reference to a requirement of going back.
Yes.
So my performance in a year preceding, the year under consideration, cannot be a ground or cannot be a factor to write my thesis here. It has to be for my performance in that year only.
Yes.
This is my limited submission, my lord. This impugned order has to go. And my lord, my lord may consider the reasons given. And if my lord finds it germane, at least that 1 mark should be given. And the last direction of this honorable court in the earlier round of litigation is to be directed to be complied with by the bank.
What is that last order?
That page 121, that they will hold a review DPC, my lord, for that purpose. Taking my APR to be 60, and then, my lord, they will hold a review DPC. Because the chance given to them, my lord, they have,
This order was passed in,
my lord, on 14, my lord, 11/8/2015,
subject to finding,
subject
to the
my enhancement.
enhancement,
But they, my
which
lord,
they have rejected.
they have rejected on perverse grounds. If they had rejected with some material, my lord, it would have been a different issue altogether.
All right. Yes. Mr. Dotto, you want to reply on some other date?
My lord, can I propose a date, my lord?
Certainly.
12th October, my lord.
12th of
October.
12th October. 21 hearings. We'll keep it on 17th
17.
October.
Yes, that can be.
That's 17 October. For
Subject
further
to
hearing
reply,
on-
my lord, if required.
Is it convenient for you?
Yes.
17 October.
Much obliged.
For further hearing on 17 October. Heard Mr. U.K. Nair, assisted by Mr. M. Pitcher. Mr. S. Dotto, Senior Counsel, assisted by S. Musari, Learned Counsel, appears for the respondent bank. Further hearing on 17 October.
Much obliged.
Much obliged for the accommodation. Lord, in this case, my lord, although I appeared, Lord, on behalf of my lord, Chiranjeev Das, I have the instruction, I received instruction yesterday evening. I need not appear, my lord. Because the advocate who engaged me, he give me a ring, my lord. And my lord, saying that,
Is there anything live here?
Lord, I think my lord, petition doesn't even survive. Because promotion order was challenged.
All right. You, Mr. A.K. Purkashta submits that he is no longer engaged in the matter. And therefore seeks liberty of the court to withdraw. Submissions of the learned counsel is noted. Since no other counsel appears, matter stands deferred for the day. Passed over for the day. Oh, that he appears for the respondent. Yes. Yes.
Lordship, in this case, Lordship, with nutshell is that Lordship, the petitioner Lordship was appointed Lordship as Lordship extension of the credit Lordship.
Extension officer?
Credit under PNRD department Lordship. Lordship, the appointment data is Lordship in page 20 Lordship.
Pleadings are complete.
Lordship,
Affidavits?
affidavit file Lordship, what happened Lordship? During pendency of this case Lordship, the department initiated the process for regularization. Then Lordship, the personnel B department, the concerned Lordship said no objection. Then the matter goes to Lordship APSC. APSC said no objection. Thereafter Lordship finance and the finally Lordship the cabinet memorandum was Lordship prepared Lordship, and on the last occasion on Lordship 28/7/2022 Lordship 28/7/2022 the PNRD department Lordship took some time Lordship.
Yes, cabinet decision.
Yes Lordship.
My lord, that particular cabinet decision is still awaiting. We'll receive the instructions within a day or two, my lord. Lord, may take it up next week.
Mr. Hendrik, learned counsel for the PNRD department submits that the cabinet, the decision in respect of regularization of the petitioner, which was placed before the cabinet, is still awaited. He prays for.
After vacation, it may be taken up, my lord.
Lordship, petitioner was already retired in the year on 30th.
After 2 weeks. After 2 weeks. Mr.
Date may be this time. Right,
AMS Majumdar for the petitioner list in November. Give a date in November. Make it 15 or 17. 17 November.
Well, the six number
My lord,
Why this is in part one? It should go to part two hearing. Why in part one hearing, 2020 matter? Is it termination?
No, no. That is removal modified, now only reduction of pay scale.
Reduction of pay scale.
not in all cases, in 3 cases.
Rest are termination.
My lord, 3 persons terminated in the revision, my lord, they reinstated, my lord, but they lowered, my lord, 12 increment reduced, my lord, with
Hmm.
cumulative effect.
Hmm.
And other 3 petition, my lord, 5, my lord, increment, my lord, with cumulative effect.
So let it go to November. It should come in part two list. This part one is for very urgent matters, old matters. We are taking up part two matters.
Lordship, my lord, but to my lord, I know it's very difficult.
No, আজিকালি part two পৰা উঠাই উঠাই part one ত দিয়ে।
We are hearing part two matters. Matters which are being heard, continued are being listed in the part one list.
3-4 cases daily
Yes.
updated
every day.
in part one.
Yes, Lord, after vacation.
Matters be listed for hearing in part two list. In the next part two list. See, if it is urgent, you can mention it. We'll take it up. We'll upgrade it if required. But the problem is listing in part one, if it goes out,
Right.
then it is difficult to find a slot for listing it.
Yes, Lordship.
We listed in the part two list.
Right.
16
Okay.
to
21
21.
obliged.
Twenty-two. 22.
It is your lordship. Lordship, on the last Friday, they have filed their affidavit, lordship, as per the direction of this honorable court. On affidavit is not on the record, lordship.
Lordship, I have the filing slip of 30 Lordship, but office cannot find the file. That is why I have tried it from the morning itself.
All right.
I have extra copy if Lordship.
No, let it come on file.
Lordship.
It is submitted by the learned CGC that in terms of the earlier order dated 19/9/2023, the affidavit has been filed on
39.
3009. Stop, however, the same is not connected to the case record. Stop registry is directed to trace out the affidavit stated to have been filed and connect it to the case record. Mr. Ritesh Buru appears for the petitioner. Please.
13 lordship if possible.
All right, on 13.
Much obliged.
Please, Lord. My lord, the lordship is directed to submit the orders.
There's some other matters pending, Mr.
Yes.
Chaudhary,
Yes.
before some other court.
My lord, the similar employees, my lord, of the NRC, my lord. Similarly appointed, similarly terminated, my lord.
Oh, this was the best.
Hmm?
বিপ্লব
বিপ্লব কিন্তু টেক করে দিলে হেতুর লগত সুরেনের লগত the same issue, my lord, same issue is pending, my lord, in these two writ petitions.
Yeah, what do you say? He says it should be connected to.
Lordship, similar matter, Lordship, all these, there are 5 cases. All these relate to, Lordship, release of the contractual employees in the NRC.
No, he submits that these matters should be connected with the other writ petition. That's all.
That's not difficulty because issue is the same.
All right. Learned councils submit that similar writ petitions are pending.
Yeah.
And it is submitted that these matters be connected along with the These are the two writ petition,
Yes, my lord.
2 or 3.
Uh, I have submitted two, my lord, 3148 of 2023.
How many writ petitions are pending?
Lordship, I'm just giving the numbers. 470 of 2020,
Yes.
577 of 2020,
Hmm.
2831 of 2021,
Yes.
6140 of 21.
Hmm.
Are we talking about a select?
3148.
No, 57.
Yeah,
Three,
last
and
one.
the last one of Lordship, 3148 of 23.
So these matters be listed along with 3148 and 2831 on
My lord, it's fixed on fifth, my lord, other matter. 3148.
hmm?
3148 fixed on my lord, fifth. My lord.
Which court? This court.
No, my lord, the list is not out, my lord, but last, it is.
When
fixed
was it listed?
on,
Who- Fixed
Next.
by which court?
fixed by my lord, court number 10, my lord,
So
on 5th of October. Day after tomorrow.
registry will examine and list the matters before appropriate bench. Mr. Kadir and Mr.
I'm appearing for the NRC.
Chaudhary, Mr. Kadir for petitioner, Mr. Chaudhary for NRC. And MS Peer Talukdar for state.
All others are.
She's from the state government and central government, Mr. A.K. Datta.
AK?
A.K. Datta.
AK. All right. Okay.
Lovely.
Lordship, senior is in lakes kindly adjourned for that day, Lord.
Item 22, Victor. As it is submitted, doing council is not available. Yes.
Yes.
Artpu is any. Hello. Okay. All right.